Recording in progress.
Good evening, everyone. Online students, can you hear me? Zoom में ज्वाइन नहीं किया लोगों ने? ये लिंक कब भेजा है? Today we are going to discuss a very important legislation, that is the mediation bill. I am using the word bill, not an act, because so far I know the President has not given the assent, right? So that will be given. The Parliament has passed the bill. This mediation is mediation bill 2021, because the bill was introduced in 2021. Later, the bill was referred to the Standing Committee of Parliament, the Standing Committee on Law and Justice, Personnel and Pensions. Anyway, so the committee made some recommendation, and some of the recommendations were incorporated in the bill. Later, bill was introduced in the monsoon session of the Parliament. Then the bill was passed. What we are going to do here in this lecture is to find out the exact nature, I mean what is the concept of mediation, how mediation is different from arbitration, conciliation, right? Second, we will see the significant features of this bill, and we will see the impact, the benefits of this bill. Next, we will see the weaknesses or criticism of this bill. Then we will see what must be done. So the lecture is structured in such a way that the entire syllabus with respect to this mediation will be covered, right? So let us understand, before getting into this features of the bill, let us understand the concept of mediation. Before understanding mediation, another concept has to be understood, that is ADR. You must be very familiar about this. You will get the PDF, you will get the printed material, right? It is on the way. But what I am discussing is not there in the material, right? So, in order to understand mediation, you should understand ADR. ADR stands for Alternative Dispute Redressal, or let's say alternative dispute resolution. So alternative dispute resolution is a type of dispute resolution where resolution of disputes happen outside the ordinary court system. When resolution of disputes happen outside the ordinary court system, such type of resolution, such type of dispute resolutions are known as alternate dispute resolution. ADR is a mechanism where dispute resolution happens outside the ordinary court system. So we have an ordinary judicial system, from the Supreme Court to High Court to the subordinate judiciary, right? But if the resolution of dispute happens outside this system, then we generally call them as alternative dispute resolution. There are multiple methods or modes of alternate dispute resolution. Some of the prominent methods of ADR are: number 1, arbitration; number 2, mediation; number 3, conciliation; negotiation; judicial settlement, etc., etc. But when we study as part of our GF syllabus, we study these things: arbitration, conciliation, and mediation. Arbitration is a type of alternate dispute resolution where a neutral third party called arbitrator conducts the proceeding. Mediation is a type of alternate dispute resolution where a neutral third party called mediator conducts the proceedings. Conciliation is a type of ADR where a conciliator conducts the proceeding. In arbitration, the process is adjudicatory. The arbitrator acts like a judge. The arbitrator hears the evidence and decides the case on merit. The parties to the arbitration proceeding do not participate. Let's say, don't write do not participate. The parties into the arbitration proceeding do not mutually explore solutions. See what they do. Let's say I am the arbitrator, the person who does arbitration. You are party, this is party A, party B. You will present your case to me either through yourself or through an advocate. That party will also present. You will cite evidence, you will cite facts, etc., etc. You don't talk to each other. And I will decide on the basis of merit. This is arbitration. Arbitration is more formal, more structured, less flexible. Arbitration has more adversarial nature. Adversarial means, like in court proceeding, generally one wins, one loses. Adversary. Ordinary court proceeding is based upon the principle of adversary principle, adversarial nature. One advocate will say, I have done the right thing. He is a liar, he is a thief. Other advocate will say, no, this is wrong. This is how it proceeds. Ultimately, the judge will pronounce the judgment. But in ordinary court system, the Indian Evidence Act, CRPC, CPC, and various other statutes are followed. But in alternative dispute resolution, what happens is, the rigor of law is very much less. It is not necessary that the entire system of law should be followed by the arbitrator. Right? Arbitration in India is conducted under the provisions of Arbitration and Conciliation Act 1996, amended in 2019. Mediation, on the other hand, is not adjudicatory. The process of mediation is based on negotiation. So it is negotiation. The role of the mediator is not to judge, but to facilitate, to enable. What? Enable what? Discussion and interaction between the parties to the dispute. The mediator provides scope and opportunity for the parties to explore solutions, to reach to mutual understanding, develop some sort of consensus, and settle the matter based upon compromise. Are you understanding the difference? Conciliation. Conciliation is similar to mediation. However, conceptually, there is a fundamental difference between conciliation and mediation. The fundamental difference is that the conciliator actively intervene in the proceeding. He is more than a facilitator. He is more than a facilitator. He also proposes solutions. He actively intervenes in the proceeding, unlike a mediator who simply observes the proceedings and try to create conditions for people to discuss and mutually agree. But a conciliator can propose solutions. He actively intervenes. If one party does not want to continue with mediation, he can, let's say, persuade, encourage, etc., etc. But at the international level, conciliation and mediation are used interchangeably. Before the enactment of this bill, enactment of this legislation, in India also conciliation and mediation were considered different. But this mediation bill 2021 removes this distinction. As per mediation bill, mediation and conciliation are used interchangeably. Are you able to understand? But there is a conceptual difference. There may not be legal difference, but exists a conceptual difference, and the conceptual difference is, while conciliation is more interventionary, mediation is more detached. Conciliation is more formal, mediation is less formal. Why? Because conciliation, arbitration conciliation act was there, is there still. But earlier, the arbitration conciliation, the provisions in the act determined the procedures and process of conciliation. But it is true that the mediation bill also provides some kind of provisions. But again, conciliation is more formal, mediation is less formal. That is why mediation is the most preferred route of alternative dispute resolution among all three. Are you able to understand what is mediation? This mediation, conciliation, etc. are provided in various statutes, independent laws. Like arbitration is governed by Arbitration and Conciliation Act. Before the mediation bill, the mediation was also provided under various statutes, like let's say section 89 of the CPC, Civil Procedure Code. There is a provision for this. Lok Adalat. Lok Adalat also provides for Legal Service Authority Act. Legal Service Authority Act, LSA. This act provides for Lok Adalat and permanent Lok Adalat, two things. This Lok Adalat uses compromise or settlement. Don't go by the term, don't worry, right? Almost same thing, don't worry about this compromise, settlement term, etc. Also conciliation. Here it is decision on merit. Permanent Lok Adalat deals with public utility like transport authorities, water body, not water body, that water board, like we have the Delhi Jal board here in Delhi, right? Similar, so those disputes of citizens with the utilities, that can be addressed through permanent Lok Adalat. But permanent Lok Adalat can also decide on the basis of on merit, which means who is right, on the basis of that can give on merit, which means one individual can lose, another can win. Simply keep in mind, Lok Adalat, this LSA, Legal Service Authority Act, provides for alternate dispute mechanisms through Lok Adalat and permanent Lok Adalat. This is one. Second, you have Consumer Protection Act. Under this, mediation provisions are given. Commercial Courts Act, etc., etc. Right. So there are various other statutes under which mediation provision or conciliation provision is also given. But what this mediation bill does is, it is trying to streamline the process. As of today, I mean earlier I would say, this process or mediation provisions, etc., were scattered in various laws and various statutes. So there was no streamlined procedure that is available, right? So this mediation bill addresses this lacuna. It provides a proper system, structure to the entire mediation process. It formalizes and institutionalizes the mediation process in India. ADR you can also see in Family Courts Act, family courts. Family courts also deals with conciliation as well as dispute on merit. First they will try to conciliate, compromise. If that does not happen, then they will provide judgment as far as the merit of the case is concerned. Don't think that ADR is limited to this Lok Adalat. You have a general perception that ADR means Lok Adalat. Lok Adalat is the mechanism for conducting ADR. ADR is a concept. Lok Adalat is a mechanism, a platform, right? PLA is also a platform. These are modes or methods of ADR. Clear? Now let us see the significant features of this bill, mediation bill. The bill makes mediation voluntary, not mandatory. Voluntary means whoever wants to have this mediation, they can. It is not mandatory, which means if there is a dispute between you and me, civil and commercial, because this mediation bill deals with civil dispute and commercial dispute, not with criminal dispute and various other disputes. So if there is a civil dispute between you and me, like let's say relating to some property or something like that, right? Then so I can either go to civil court, ordinary court, or I can go for the mediation. So it is my choice whether I want to have mediation or ordinary court. Right? Earlier the draft bill, 2021 bill, made the mediation mandatory. Now it is not mandatory. So voluntary mediation, number one. Second is applies to civil and commercial disputes. Very good. It is also applicable to governments, but only insofar as commercial aspects are concerned. When there is dispute between a citizen and a government, let's say relating to land acquisition or some property, some compensation, these are not commercial disputes. So these disputes will not be come under the mediation. Disputes with respect to the government will only fall in mediation if the dispute relates to what? Commercial dispute. Commercial disputes are defined under various sections of the Commercial Courts Act. Anyway, leave it. Just keep in mind that only commercial disputes are governed as far as governments are concerned. The government term we are using is very wide. Federal government, state government, local government, public utility, departments, independent regulatory body like SEBI, TRAI, etc., etc. So there is huge exemption as far as government is concerned. All the government is included as far as the commercial aspects are concerned. Next, this provides for institutions in order to implement, execute the provisions of the mediation bill. One institution is the Mediation Council of India, MCI. Mediation Council of India. This is the apex institution that will implement various provisions of the mediation bill. Right? It will set standards of mediation. It will train mediator. It will recognize mediator. Right. So, Mediation Council of India. It will be headed by a chairman, and the Mediation Council of India has, I think, 7 members, including government representatives. 7-member body, we have provided that. Not important in that sense, but one thing is important that I will discuss in the criticism part. But keep in mind, this provides a 7-member body, right, which will oversee the implementation of the bill, providing training to the mediator, conducting studies, let's say, and recognizing the professional mediator, right, etc., etc. It also provides for establishing mediation service provider, MSP, mediation service provider, which means, let's say I have a dispute, you have a dispute, right? So we both decided that we should approach a mediator, right? So I will approach this mediator, that mediator, this mediator. Similarly, right, let's say you want to eat something, hotel is service provider as far as food is concerned. Which hotel you want to go, you can go. Similarly, various mediation service providers will be set up under this. They will be registered under this MCI. They will be given accreditation, etc., etc. So individual referees for mediation can approach mediation service provider. After the mediation, there will be MSA, mediation service agreement. Mediation is a consensus based system. I am the mediator, you both came to me, right? We discussed, etc., etc., etc. After a lot of discussion, negotiation, etc., we decided that yes, this can be a solution. It's a mutually agreed solution. Mediator cannot impose. There will be solution only when both parties agree. Otherwise, no solution. Right? Let's say this mediation went on for 3 sessions, 4 sessions, 5 sessions, 2 months, 3 months, but nothing has happened. Then you can stop mediation and you can go to ordinary court. Point is that mediator will provide his award only when the clients or parties to the dispute agree. That is how it is, consensus based. Nobody can force you to accept it. Otherwise, in the court there is one judgment. Whether you lose or win it, you have to accept it. It is binding. Here, the mediation service agreement will be based upon the consensus of the party. But once you agree, then the award is binding on all of you. Once you agree that I am agree for it, I have signed it, then it is binding upon you. So this bill provides for binding and enforceability of the award by the mediator. Binding and enforceable. Once the award is given, once the document is signed and final award is given, right, that award has the sanctity of a court order. It is like a civil court order, which means binding on parties. Generally, what happened with this alternate dispute resolution is, once the mediator or that individual gives an award, to execute it, to make it legally valid, the parties have to go to the court, and the judge will sign it and authenticate it. But this requirement is dispensed with under this bill. Automatic enforceability, in the sense of automatic authentication. This bill also deals with international mediation. So bill also provides scope for international mediation. According to this bill, international mediation is one where one of the parties is a foreign company or individual, and the mediation is conducted in India. Okay? This bill also provides for online mediation. Online. So the mediation is more accessible to people, because online you don't have to go to the place where the mediation happens, right? Even you are from the village area, rural area where this MSPs might not be there, you don't have to go to the cities, you can conduct online. There is another portion for community mediation, very much required as far as India is concerned. The community, If there is a problem in community, the community mediation can be there. It provides for 3-member panel. Let's say you are living in a colony, housing colony. Some dispute happened between you and your neighbor, right? You are studying and somebody has switched on the stereo, audio, there is party, right? Problem. It can happen. So the RWA can set up a panel of 3 and there can be mediation between you and your neighbor. Similarly, in larger society also can be done. Community mediation, which will help what? Peace and harmony, brotherhood, fraternity, etc., etc. But one issue is community mediation award is not binding and enforceable, unlike others. Which means even if the award is given, then it has to be authenticated or legally stamped by the concerned authority. But anyway, that's a different issue. Don't worry about that. But still, it provides for community mediation. As far as we are concerned, this is very much required. But there are problems that we will see. These are some major provisions as far as bill is concerned. Now let's see the significance. Why the government has brought this bill? First significance is this provides for institutionalization of mediation. The term institutionalization means establishing a system or a structure in order to deal with a particular activity. Institutionalization, establishing a structure, system or an organization to deal with a particular activity. Institutionalization of fair and free and fair Election Commission of India. Institutionalization of competitiveness in the economy, Competition Commission of India. Institutionalization of alternate dispute redressal system through number of laws like the Legal Service Authority Act, family laws, etc. plus mechanisms. Don't confuse that institutionalization means only institution. No. The term institution implies establishing a system to deal with a particular activity. The system can be established through a system of law. Under that law, institution can be set up. Right? Law, rule, regulation, and organization. Institutionalization. Establishing. It becomes permanent. Something which is done ad hoc, intermittently, now becomes systematic, structured. When you write an answer abruptly, without any coherence, without any structure, just putting information, that is ad hocism. It has no institutionalization, no structure, no. There is no organization, right? So mediation, this mediation bill provides for institutionalization of mediation through setting up institution like Mediation Council of India and the mediation service provider, and also by this legal system, that bill itself. So as of before this bill, what the situation was, the mediation system in India has been scattered over multiple laws and it has been conducted by multiple agencies. So this bill provides a systematic overhauling as far as mediation is concerned. This bill provides for a mediation ecosystem. Second importance is, as you know, that this will improve access to justice, because you all know that the problem with the court, access to justice is linked with the pendency, or let's say pendency in the case, pendency of cases in the courts. 4.43 crore cases around are pending in subordinate judiciary. Around 60 lakh cases pending in High Court. 70,000 something pending in Supreme Court on an average. 50 lakh, 70,000 Supreme Court, 50 lakh High Court, 4.43 something in this what we say subordinate court. So more large number of cases are pending here. So what if student in individuals to take up to mediation, then the cases will remain almost the same. It will not be added. So it will lead to efficient justice delivery, easy justice delivery, access to justice also, because mediation will provide an award. That is also justice. You don't have to go to the entire court system. It is true that there are some exemptions as far as mediation is concerned. As I mentioned, only civil and commercial are applicable as of now. Criminal is out of the ambit of mediation bill, but still civil dispute are covered. And as you know that the civil dispute is something which has a huge portion as far as the pendency is concerned. And there is a saying in English, if you win a civil dispute, then you are lost. And if you lose a civil dispute, then you are dead. It means that the delay takes decades. Win it. That is what it is meant by this. So this provides access to justice, resolution of disputes in an easier formal manner, informal manner. This also can have impact upon ease of doing business and let's say ease of living. Very easy. Commercial disputes are part of it. Companies and the corporations and others can use mediation. Very easy to, right? So the delay, the court process will not be a problem. They can do it. So disputes are resolved. Then contract can be enforced. As you know, so-called ease of doing business report, contract enforcement as far as India is concerned, rank is very poor. So before doing business, contract can be enforced. Or whatever disputes are there, right? So it will remove ease of doing business. Ease of living, which means that this is linked with the other, let's say community mediation, ease of living, right? Neighbors, they can go to this mediator. So it will be peace and harmony in society as far as this mediation is concerned. Ease of doing business will improve economy, isn't it? Employment opportunities, there will be less a problem of, let's say, management and employee issue. So there is overall likelihood of betterment of life. Another significance of this bill is it provides scope for international mediation. So India can emerge as a hub of international mediation, because this mediation bill also provides for conducting international mediation. But there is a catch here that we will discuss in the criticism part. Another important significance of the bill is the enforceability or binding nature, which means once the award is given, the award is automatically enforced. So the individual need not have to go to another authority. So this will provide more incentive to individuals as far as mediation is concerned. The role of Mediation Council of India as far as this bill is concerned is very significant. The Mediation Council of India can issue regulations. It can train individuals. It can register the service providers. For providing the institution of Mediation Council of India will enable creation of an organized mediation system in India. This Mediation Council of India is an organization which has responsibility for development and regulation of mediation. Another significance of this bill is the fundamental principle of mediation is consensus, voluntarism. This bill underscores that principle by making mediation not mandatory. This bill also provides for challenging the award given by the mediator on the basis of if there is fraud, corruption, right, misappropriation, something like that. There are few grounds under which it can be challenged. Another significance is it provides for time frame. Yes, very important. This bill provides for a time frame for completion of mediation. 180 days is a time frame under which it has to be completed. This 180 days also includes the days of extension. Means if, let's say, initially the time is 90 days, but in 90 days you have not reached any compromise, settlement, then it can be extended up to 90 also. Simply, the maximum time limit for completion of mediation is 180 days. This 180 days includes also extension. Don't use this 90 plus 90, right? Just understand this maximum is 180, which includes extension, which means the time frame is provided. These are the significant facets of this bill. Now let us consider some criticisms of this bill. This is important. The fundamental issue is what? Government exclusion. Government is one of the largest litigants in this country. Now you are including only the government. That too, the explanation of government is very wide. Local, federal, state, regulatory body, utilities, and others, boards, commissions, etc., etc. All of these entities are excluded. Why? No reason is given. Ultimately, government should enable, initiate, government should take leadership in popularizing mediation. There is no reason that why government is exempted, why non-commercial matters are excluded as far as the government is concerned, given the fact that government is one of the largest litigant. I think in the Supreme Court itself 6 lakh cases, not 6 lakh, I don't know, I'm not exactly getting not 6 lakh, leave it. The data is not important. 50% cases, something have the CJ Ramana has said, more than 50% cases. He has said that more than 50% cases in the entire country, pendency, as far as pendency is concerned, it is because of the government. There have been multiple, court observations saying that there should be litigation policy as far as the government is concerned. Government should take the ADR mechanism instead of approaching the ordinary court. Even the Attorney General of India also, the incumbent Attorney General also said that government should take more this ADR mechanism in order to resolve issues. So ideally, the government and various government agencies should have been brought as far as non-commercial this is concerned, activities are concerned, right? This is a very significant exclusion as far as this bill is concerned. Next is the issue with MCI, this Mediation Council of India. The composition of Mediation Council of India does not provide for an individual who is a practitioner of mediation, which means the composition, the individual who can be appointed as chairman as the members of this MCI, their qualification, they don't have to be qualified in practicing mediation. It simply says a person who knows ADR, alternative distributor, who has knowledge of mediation. But the point is that this institute should be run by individuals who have practical knowledge, who is a practitioner of mediation. Let's say Medical Council of India, Bar Council of India. Who is the chairman of Bar Council of India? An advocate? Bar Council, Bar. Bar Council of India is a professional body that regulates the profession of law. Similarly, medical NMC, National Medical Commission, is a body that regulates the profession of medicine. Mediation Council of India is a body that regulates the profession of mediation. So there have to be people who should be well versed with it. But as far as composition is concerned, it does not provide for individual who is well versed practitioner of mediation. Second, MCI is structured in the form of a regulatory body which will regulate the mediation. But unlike other regulatory bodies, like I mentioned, NMC, this Competition Commission of India, BCI, ICAI, all those things, this MCI cannot make own regulation unless approved by the central government, because regulation can be made. Bar Council of India can make regulations in order to implement the various provisions of the Act. But for making that Bar Council regulation, it doesn't have to take permission from the federal government in general. Generally, when professional regulatory bodies are set up under various statutes, they have autonomy to make regulation within the framework of law. So ultimately, setting up a regulator is to act independently of the government. Regulator is working as hands, what is that? Arm's length approach. Otherwise, it will not be able to regulate independently. So in this case, it has to regulate or implement this mediation system. But for every regulation, it has to take permission from the federal government. Because the federal government is one of the party to the mediation, do you think that regulation issued by the MCI will be reflective of the interest of the government of India? Very much possible. There is a conflict of interest. Ideally, this should have got independence in that sense, independent to make regulation within the larger framework of the law, rather than taking permission from the federal government. Clear? Another issue is with the international mediation. International mediation.
Government is excluded from mediation process.
No, government is not excluded from mediation process. Government, as far as the non-commercial activities are concerned, governments are excluded. Not only government, governmental body, in the sense of this independent regulatory body, SEBI, TRAI, Competition Commission of India, all these are excluded. Wait, let me explain. Federal, state, local, government, right? Government proper. Their their commercial activities are covered under dispute. PSUs, TRAI, SEBI, they are completely excluded from the mediation system. Let's say a company dealing with this telecom system might have some issue with the TRAI. It is very much possible that the company can enter into mediation with it. This is excluded. Not only that, this mediation bill also excludes some laws which you mentioned there. Family law, that Family Court Act, maintenance of what is that Senior Citizens Act, sexual harassment, etc. All these are also exempted from it. Now you ask.
Is government completely excluded? Or
No, that's what I'm trying. As far as commercial cases are concerned, governments are included. Commercial case. Let's say PPP, or let's say government entered into a contract with somebody. That Vodafone, not Vodafone, that's a different thing. Let me say, let's say government wants oil. So government entered into a contract with an oil company outside India or inside India for that matter. This is commercial. taxation case, land acquisition case, right? Property issues, compensation. But as far as the TRAI, SEBI, etc., their entire activity is excluded. Some special laws, Family Court Act, this Maintenance of Parents Wala Act, and sexual harassment, these things are also excluded. There is no reason why these are excluded. Because ultimately these laws are dealing with very sensitive issues. So ideally, as far as family or the maintenance of parents, etc., should have been also been ideally included in this. But anyway, the point is that let us come to international mediation. Although this recognizes international mediation, provides for international mediation, according to the bill, international mediation is when one party is a foreigner and it conducted in India. Now, this does not recognize if the mediation is conducted outside India. This mediation conducted outside India is not recognized under this. Another problem with this is the provisions of the mediation bill is not in consonance with the Singapore Convention. Singapore Convention is the convention which deals with mediation. There is the UNCITRL, UNCITRAL, United Nations Convention on International Settlement, something like that. It's a very difficult, what we say, expansion. UNCITRAL. So under UNCITRAL, there is a convention that is known as Singapore Convention, right? So Singapore Convention provides for cross-border recognition of, I am not reading from it, don't worry, I am just seeing the full form of UNCITRAL. UNCITRAL full form, yes. United Nations Commission on International Trade Law. Not this one, not this. Wait, not this one, not UNCITRAL. This is Singapore Convention. Not UNCITRAL, this is United Nations Convention on UN Convention on International Settlement Agreement resulting from mediation. Don't worry, you don't have to remember this, right? This convention is also known as Singapore Convention. Just keep that in mind. So Singapore Convention on Mediation provides for cross-border recognition and enforceability of mediation. But this Singapore Convention, India signed but did not ratify it. But anyway, Singapore Convention is a convention which provides more scope for India to emerge as a hub for international mediation. How? Because if India ratify that, then the provisions of that convention will apply. Then the mediation will be conducted. As far as international mediation is concerned, it will be under this Singapore Convention. The Singapore Convention does not recognize awards of mediation which have the status of a decree of a court. Simply means, as I mentioned, an award of a mediator is what? Enforceable. It is deemed to be an order of the court. This is the mediation bill says. But as far as the Singapore Convention is concerned, the Singapore Convention does not recognize this aspect. It is not applicable to those mediation awards which have the status of a court order, because this court order provides lack of flexibility to mediation. If international disputes are happening, companies are coming and mediating, right, and they require some flexibility as far as the enforcement is concerned. So the mediation, Indian mediation bill and the provision with respect to international mediation is at variance with the Singapore Convention. Singapore Convention provides flexibility even after the mediation award is given. But Indian mediation bill provides the status of a court order, right? Court order of this mediation award. So this will provide less incentive for the international companies and groups and players to come to negotiate in India. So this bill does not provide for international mediation conduct outside India. Indian party, let's say A and B are Indian, they want to conduct outside. What will happen to that? If one is Indian, another is international, conducting outside, what will happen to that? Anyway, wait. This bill says international mediation is one when one is a foreign entity. So this cannot happen when both are Indian, then they are conducting outside. So it will not be international mediation. Number one, fine. But if it is foreign, if it is Indian, then what if they conduct outside? What will happen to that? Right. Second is that the mediation, one foreign conducted, one Indian, both conducted in India. It has the status of a court order. Then it is variance with the what we say Singapore Convention, which means it cannot be enforced outside. An Indian company is going global. Indian companies are going global. So Indian companies have various assets in various countries. So if there is a MNC out, let's say from USA, conducting mediation with an Indian company who have outside operations, right? They will not be having any incentive to conduct the mediation in India. Why? Because this cannot be enforced outside. Company A in India, Indian company have many assets outside. So mediation means, let's say mediator awarded huge amount of money to that individual. Both agreed. Later one said that I don't have any money in India. Indian company said I don't have any money in India, nothing. But he or she has outside. But Singapore Convention will not apply. So what they do? They go to Sri Lanka, Bangladesh, various other countries instead of coming into India. Simply keep in mind, the provisions of the mediation bill is not in consonance with the provisions of the Singapore Convention. This will produce, this may deter the scope for international mediation. Hence, it can reduce India's opportunities to emerge as a hub for mediation, international mediation, right? Way forward, very easy. What can be done? First thing is that rethink as far as the exemption of the government is concerned, and also it is better to bring what? Those TRI and all those people inside this mediation. Clear? The provision with respect to MCI, their composition and regulatory power needs to be relooked. Second, you know that this is a very good transformative bill which can deepen the process of mediation and declog the courts in India. This requires proper implementation, awareness generation, creating a system, infrastructure, human, technical, physical, all those things should be set up. Another is online, but online, as you know, this Nidhi Aayog report, there is a report of this Nidhi Aayog which says that 55% of Indian people have access to internet, something like that. This requires net connectivity, as you know, this digital divide issue, isn't it? Another way forward is you need to ratify the Singapore Convention, and accordingly, through rule or amendments, the bill can be made more in consonance right with the Singapore Convention. But again, this bill, the significance, we mentioned that this bill is a very important bill because mediation is the most preferred method of ADR because of its flexibility. That is why this bill needs to be implemented properly. The implementation system that is set up has to be established, because we have an example, Arbitration and Conciliation Act. Under that, it was amended in 2019, and the Arbitration Council of India was provided. To date, it has not been set up. That legacy should not be replicated as far as the Mediation Council of India is concerned, right? And the local bodies and states are also need to be roped in order to decentralize the process of mediation. Ultimately, central bill. A lot of things happen at the local level and the state level, isn't it? The Parliamentary Standing Committee, which examined this bill, recommended that the exemption given to the government should be relooked. It has to be done. Before parting, I want to give you two more new insight. This will help you where? In various other questions. Number one, Supreme Court of India set up a committee earlier, right? Set up a panel to study and report and recommend as far as the mediation is concerned. This panel studied, reported by the Supreme Court and set up and provided some host of recommendations. And they also said that a bill has to be established or enacted and a system has to be there in order to institutionalize mediation. Supreme Court forwarded that recommendation to the government, and government decided that yes, this is an important suggestion of the Supreme Court, and the bill is drafted. So this is an example of judiciary instead of judgment. Are helping or let's say persuading the government to bring a bill. Let's say Supreme Court provided judgment, enact that bill. That will be kind of activism. Here what judiciary is doing? Judiciary is nudging or providing evidence-based support to the government. So this is an example of judiciary and the government working together. And how the judiciary is helping to fill up the vacuum, legislative vacuum. Right? Second is the role of Parliamentary Standing Committee. Parliamentary Standing Committee, that is Departmental Standing Committee, DRSC, Parliamentary Standing Committee on Personnel and Law and Justice. That's a committee. That committee studied it and they provided a lot of recommendation. One recommendation was make the mediation voluntary instead of mandatory. Government accepted it. This is an example of a Departmental Standing Committee. Its role, function, studying, right, and recommending, and the government amended it. Generally, what we say that DRSC are not functioning properly, isn't it? Bills are not referred to it, all those things. So use it as an example in order to support. Yes, DRSC are functioning properly. Not only example, use this study. I mean, instead of writing multiple examples, what you do is take one example and write few lines on it, explain it properly. And if you have time, then you refer others. Instead of referring multiple examples, take one example and explain it properly. This DRSC will help you in that. This mediation wala. This committee also said that 180 days. Earlier it was 180 plus 180. Initially 180, next 180. The committee said reduce it. Committee said make it 90 plus 60. 150. But they reduced to 180. But anyway, the point is that you write it this way. The committee also recommended that there should be reduced time span as far as the conclusion of the mediation agreement is concerned, not mediation process is concerned. And accordingly, the government also accepted it and reduced the time period with some modification. Before going, one last point, principles of mediation. Principles of mediation. Voluntarism. I am writing very short, time is running out. Voluntarism. Consensus oriented. Confidentiality. Informality. Consensus, voluntarism. Inexpensive or cheaper. Flexibility. Are you able to read? Consensus oriented, confidentiality, informality, inexpensive or cheaper, flexibility, voluntarism. Principle of ADR is, you can also use this right? Principles. Anything you want to ask, you can. Huh? Sorry?
I'm getting my wife.
Yes, I am.
Sir, if you bring the government institutions in the mediation bill, the partners, those are the against the some of the development. They will put the inmate fire mediation code. That will affect the development. Example, Vodafone has been won by the.
Do you think that, wait. Do you think that those people cannot approach the court?
Sir, they will approach the court will go to very slowly and they will verify the internal way. But in the mediation will go.
Mediation requires consent of both the parties. The government says we are not willing for mediation. Then no question. I am the government. Let's say you are the government department. I am the farmer. Right? I want to stall the development project. This is what you are trying to say. Point is that you government will say I am not willing for mediation. It has to be willingness by both, no mediation. Consensus oriented. It is voluntary. Both should volunteer. Then there is no question of that, isn't it? Isn't it? Clear? Show Prabhat. Yes. Anything else? Okay then, all the best. Thank you. Acha. Inexpensive or cheaper. This is informality, flexibility. I should write better. Even otherwise I'll have to. No, I know that. Even I have attended some classes for improving handwriting. But that did not work. Anyway. Anything else? Okay, then I'll see you with the data protection bill next week. Right, data protection bill. And after that, I'll deal with the NCT Services Act. In between, you will have. In between, you will have the various other topics, economy and geography, etc. And fine. Tomorrow's test, yes, tomorrow's test, you will have 4 to 5 questions. Go there and write. The classroom is available in Karol Bagh. Go from 9:30, let's say from 10 to 5, 6, go. Anytime you go and write. No, this class is occupied. That class is available, right? You take the paper and go home and write and submit here. It's okay. Right? That classroom is available. Here, this class will be occupied, and the other class will also be occupied. Separate class is there for you to write. Keep writing, right? Okay, then all the best. Thank you.